Hello everyone. As Centre is gearing up for the conduct of census, fresh controversies have got generated with respect to the delimitation process. Tamil Nadu Chief Minister Mr. Stalin has made a statement and he had called for an all-party meeting where they have urged the Centre that they should keep the 1971 census population itself as a criteria for the next delimitation. Constitution has made certain provisions in regard to this. We have been using the 1971 population census itself for the delimitation and for the allocation of seats in the Lok Sabha to the states, as also the number of seats which are there in the state legislative assembly. The reason for 1971 census is that though in the original constitution they had to make fresh adjustment after every census, but later on amendment was made in the constitution which seized it at the level of 1971 population. And this was done because all the states which have been taking good measures for population control, which have been performing better on development parameters, those states will be receiving some kind of disincentive if according to the new census figures the seats are allocated to the states, because the better performing states, they will get lesser number of seats according to all later census. Therefore, the government had decided that they should freeze the population level to the 1971 census. This is pretty well known to everyone. Now, the question is that if this controversy or conflict are going to continue, then what solution can be brought in this regard? This is what we need to explore. But before that, let us try to understand what are the constitution provisions, what amendments have been made, and then where the details of the delimitation process is given, how delimitation happens in detail, right, and which body conducts it. We will also look into briefly that what process of delimitation has been taken up so far. So let us look into the constitutional provision first and foremost. Article 81 of the constitution, it talks about the composition of the Lok Sabha. Article says that Lok Sabha will have 530 seats from the states, and all these seats means the members, 530 seats means 530 members are coming from all different states and they will be directly elected from the constituencies. So 530 seats overall, 530 overall seats are allocated to the states, and along with this 20 seats have been allocated. This is the maximum number which have been allocated to the union territories, and the article says that the manner of election of these 20 members will be according to as it is decided by the law of the parliament. Now, in relation to this, the law has been made, and that is the Representation of Peoples Act of 1950, which says that the election from union territories will also be on similar basis as it happens for the states. That means there also we will be having direct election from the union territories, right? So union territories will also be divided into constituencies, though most of them are very small. They will have mostly one seat in the Lok Sabha, but still it will be a direct election from these constituencies. Now, 530 seats to the states and 20 to the union territories, 550 is the maximum figure. Presently, 7 seats are lying vacant in union territories. So, overall number of members in the Lok Sabha is 543. So, in every general election, we conduct elections for 543 seats all across India. Now, the question is that these seats overall 530 plus 13 over here in union territories, they are allocated to the states and union territories on what basis? So the basis is also given over here in the article itself, and the basis is according to their population. So the states will get a quota of these seats in the Lok Sabha, which is according to their population. And this population itself, we were talking about that the population earlier it used to be every fresh census figure, but now this population has been fixed at 1971 census, and this is about the number of seats which are given to the states. Now there is another issue that once the seats have been allocated to a particular state, like for example if UP has got 80 seats, we have to see that how these 80 seats are going to be delimited in different constituencies. So how are we determining the constituency? This will also be considering a major factor of the population, because all the constituencies roughly needs to have a similar level of population. So here the population which is to be considered, that means the state which is when it is to be divided into constituencies, this will also be on the basis of population, for which the figure of 2001 census is to be taken up, right? And these two things, these two census figures, this has been seized till the year 2026. That means up to the first census which will be conducted after the year 2026, we are going to consider for these purposes, that is allocation of seats to the states and for the delimitation of constituencies within the states, we are going to take up the census figure of 1971 and 2001 respectively, and this is ceased till the year 2026. Along with Article 81, there is another provision given in the Constitution, which is Article 82, which talks about the process of readjustment after every census, right? And if it is not to be, because now the figures have been seized, so we need not to conduct these operations that frequently. So Article 82, it talks about the readjustment of these seats also and the delimitation of constituencies. It will be decided, the manner how it will happen, the authority or the body which will do this is to be decided by a law of the parliament. So parliament in the law will decide that which body will do it and what will be the process of this entire thing. Now herein, usually the law which parliament makes is what we call as a Delimitation Act or Delimitation Commission Act, and the body which is established is the Delimitation Commission. But remember that because the parliament has the power, it may give this power or function to adjust these things also to any other body apart from Delimitation Commission as well. So these are the provisions which are given in both Article 81 and 82. At both the places they have made references to these population figures. At both the places it has been made clear that this has been ceased till the year 2026. Now let us try to understand that how the original position of the constitution has changed into this, because that is going to make it very clear to us that through which amendments these things have happened. So there are two issues. First one is the seats which are allocated to the states, and the other issue is the delimitation of the seats within the states. Okay, it should be delimitation of seats within the states and seats which are allocated to the states. So as we know that in the original constitution, these things were to be decided according to the fresh census population figure. But an amendment was made in the first time the amendment was made in the year 1976 by the 42nd Amendment Act. What they did was that they said the next delimitation or readjustment which will happen, it will not happen according to the fresh census, rather they will be using the figure of 1971 census itself. And they have also said that we will continue to use this figure of 1971 itself for the purpose of the seats which are allocated to the states. This will continue till the year 2000. Okay, presently it is 2026, but in this amendment this was increased for like from 71 till next 30 years till the year 2000. Then second issue was how the constituencies are to be delimited, how the boundaries are to be created of the constituencies within the states. For this also they will take the population census of 1971, and this was also ceased till the year 2000. Now as we approach the year 2000, then we will have to take a fresh decision because it was seized only till the year 2000. So in relation to that comes in another amendment, which is the 84th Amendment Act in the year 2001. And by the 84th Amendment Act, what government did was this 1971 population was further continued thereafter also, and this was ceased till the year 2026. So they have extended it further till the year 2026. But for the delimitation of constituencies within the states, here they have made a change. Here now they are using the population figure of the 1991 census, not 1971 census. So a change has been made, and this will be ceased again till the year 2026. So the delimitation of constituencies within the state, the determination of the boundary, for that the population as a factor which will be taken into consideration will be 1991 census population. The reason being that when this amendment was brought in 2001 census population figures were not available. So that is why the last one which was available was 1991 census. But sooner they will realize that the 2001 census population figure has become available, and the delimitation process or readjustment process had just started. So what the government did, it brought another amendment act in called as the 87th Amendment Act in the year 2003. And by this wasn't changed, this remained the same, remained as it is. Here they have made changes. Here they have mentioned instead of 1991, now they are saying we will take the figure of 2001 population for the purpose of delimitation within the states. and these are the two population figures which we have mentioned earlier also in the previous slide. So this is very clear to us that seats allocated to the states on the basis of 1971 population and the state delimitation within the states on the basis of 2001 population, and this will be ceased till the year 2026. And now when 2026 is approaching, so obviously as the next census will happen, after the census fresh readjustment or delimitation will happen. So the question is, are we going to continue with the 1971 population or are we going to change it to the fresh one? This has to be decided. This is the reason why the controversies are being generated, and the southern states, they are adamant to ensure that they will not lose on seats, neither lose on the number of seats, but there's another issue is that they should not even get lesser proportion of seats also if in case the overall number of seats in the Lok Sabha is increased. Remember that Home Minister had made a statement recently, and he had said that the southern states or any of the states will not lose a single seat after the delimitation. And the question, now we should not be mistaken by these statements, the question here is not about whether the southern states will lose a seat or not seat. They definitely should not lose a seat, but in case if the suppose the seats goes up, let's say from 543 present it goes up to somewhere 800 plus seats overall in India, then if Tamil Nadu presently has 39 seats, then its seat should increase in that proportion itself, right? That means that in the proportion which is there right now in the overall number of seats. But if you go by the fresh population figure, Tamil Nadu will actually lose number of seats also, and proportion anyhow will be much lesser. So there is an issue. This needs to be made clear. And now the question is that what solution can be there for this? The issue is that the provision is mentioned in the constitution itself. The government either, so they look into the possibilities. The first possibility is that we take into account the fresh population figure. If we take that into account and do the delimitation according to the fresh population figure, definitely the number of seats of the southern states will go down, and this will not be accepted by the southern state. This is going to generate a lot of controversy. Even if you will say that their number of seats will not come down, that means Tamil Nadu will have 39 seats only, right? They may make certain type of exception. The question again is not about the number of seats. The question is overall proportion which they had earlier. Will the proportion remain the same or not? So for this purpose, two solutions can be there, or maybe three solutions can be there. Either you continue with the 1971 census itself. That means government brings another amendment and extend this for further period of 30 odd years. The second is that you can make certain exceptions of the states in the constitution itself, and these states it will not get affected, right? For them the seats will be determined on some other criteria, or they will not lose on to their proportion. Or we will have to make some kind of amendments in relation to that the seats, number of seats will increase. Overall seats may increase according to the fresh population figure, but the proportion of seats which the states are getting, that proportion we can keep at the 1971 census level itself. So this has to be seen as to what kind of amendments the government does, but definitely in order to convince all the states, some kind of such adjustments need to be done. That means we will have to consider either the proportion of seats issue, or we will have to keep the 1971 census level itself. So this has been the issue. Now let us also look into a little more on the process of delimitation. One more thing we need to be very clear, as I mentioned two articles, right? For the Lok Sabha we have article 81 and 82. Now similarly at the state level also we need to decide how many seats are there in the state legislative assembly from each state. This is also decided on the basis of population. And then the MLA seats, they also have to be delimited into constituencies. So for that also we require a population figure, and this is exactly similar as it is there in case of Lok Sabha. That means the number of seats in the state legislative assembly on the 1971 census population, and the delimitation within the states of the MLA constituencies will be on the basis of 2001 census. So similar provisions related to 81 and 82 is given in article 170 as far as state legislature is concerned, and state legislature here obviously means we are talking about the lower house, the state legislative assembly. Okay, So now let us look into the process of delimitation as it had been like. The article says that, Article 82 also says, or Article 170 also says that the law of the parliament will determine which authority will be conducting and the manner in which this will be carried out. So for that purpose, we are establishing the Delimitation Commission. This is established by a law of the parliament, as I told you, and this is mentioned in Article 82 and 170. Now in the previous years, it is 4 times that we have established the Delimitation Commission, because in the initial years, after every census, we were establishing the Delimitation Commission. But after 1971, we did not establish any Delimitation Commission. Then we will establish the Delimitation Commission, not for the adjustment of seats to the states, because that has ceased till the 1971 level, but for adjusting the constituency, because we changed the population figure to 2001 census. So we again established the Delimitation Commission in 2002. So let us see when all the Delimitation Commissions have been established. The first one was in 1952. This was through the Delimitation Commission Act. This is the law which we are talking about. So the Delimitation Commission Act 1952, followed by next decade, the Delimitation Commission Act of 1962. The third time we conducted a delimitation was in 1972 based upon 1971 population. This time the name of the act is the Delimitation Act. Earlier it was Commissions Act, now it is only Act, and thereafter the Delimitation Act of 2002. So this act was brought because again we had to establish Delimitation Commission, because within the state the constituency is to be decided on the basis of 2001 population. And now let's see what happens after the next census. Obviously, we will be requiring a Delimitation Commission to be established. So how this Delimitation Commission works? Let's see the appointment and the composition of the delimitation. The provisions are given in detail. The details of the Delimitation Commission will be given in the law itself. It will be given in the law itself. That means the Delimitation Commissions Act itself. So this act, now the question is, one more issue here is that every time you are establishing a Delimitation Commission, a new law is passed by the parliament. It is not that there is only one law and through that law itself every time you are establishing the Delimitation Commission. So we have already seen that the 4 times the acts have been passed. But these acts, the provisions are more or less similar. So we are going to look at what provisions were there in the latest acts, and in fact in the previous acts also similar provisions were there. And whenever the next time the Delimitation Commission will be established, more or less it will follow similar such provisions. So in the 2002 Act only we will look into what provisions are there, and these were common in previous ones as well. So first and foremost it says that it is to be constituted by the central government. The members are appointed also by the central government. The president will be appointing the members, and the composition, the number of members in the Delimitation Commission would be how many? There are 2 types of members actually. First is the 3 members, the main members which are there will be 3 members, and these 3 members will include a chairperson who will be a present or former judge of the Supreme Court. Another member will be the Chief Election Commissioner himself, or he may appoint another election commissioner, okay? Either a Chief Election Commissioner or another election commissioner appointed or nominated by the Chief Election Commissioner. The third member will be the State Election Commissioner of the concerned state. Now one thing has to be made clear, that how the Delimitation Commission is going to work. Delimitation Commission is going to be considering the delimitations state-wise. When it is doing a delimitation of a particular state, its composition will include the election commissioner of that state. And when it is going to conduct the delimitation of another state, then this composition will change. These 2 members will remain the same, but the state election commissioner will change. So according to all the states, the composition will slightly change. So that state election commissioner will be there. Along with these 3 members, the Delimitation Commission also has some associate members. These associate members include 5 members from the Legislative Assembly of that state. Remember, if a commission is conducting the delimitation of a state, then these 2 members will remain same. The third member will be that state's election commissioner, and from that state only 5 of its MLAs will be included. 5 MLAs means 5 members of Legislative Assembly of that state. These will be nominated by the Speaker of the Legislative Assembly, and 5 more members are the Lok Sabha members from that particular state. they will be nominated by the Lok Sabha Speaker. So 5 MP and 5 MLAs from that particular state will also be associated in the Delimitation Commission when that Delimitation Commission is conducting the delimitation of that particular state. So one more thing is to be clear that associate members, they will not have much power. They are there as maybe more like advisors. They are not going to participate in the decision making process. They will not have the right to vote. So mostly the decision will be taken up by these 3 members. Okay, now let us look into that. There are certain in the composition itself, they can call upon some more members from some suggestions or for some advice, whom the Delimitation Commission can call upon. So it has the power. This could be included as part of the power of Delimitation Commission also, but more or less here we are talking about, because we are considering the composition, which all people will get associated or may be called upon in the meetings of the Delimitation Commission. So it has the power to call upon which people? Registrar General and the Census Commissioner of India or their nominee, or the Surveyor General of India or his nominee, or any other officer of the central or state government, or any expert on GIS, that is Geographic Information System, because in the entire process of delimitation you will require this survey. That's why the Surveyor General is also there, because when you are delimiting the constituency, then geography is along with population, geography will also be a factor, and we will see what all factors will be taken into consideration. So an expert in the GIS will be there, and any other person of experience or knowledge can also be called upon. Apart from this, the Delimitation Commission, when it is working, then it will have some kind of a connect with the Election Commission also, though it is going to work independently, but its administration is going to be supported by the Election Commission. The reason being, the Delimitation Commission will have a ex officio secretary. That means the secretary of the Election Commission itself will act as a secretary to the Delimitation Commission. Now this generally happens when we say that the Delimitation Commission is a small body, it will not have its own administration. Whatever administrative support it will require will be provided by the secretariat of the Election Commission. Therefore, the secretary of the Election Commission is also the ex officio secretary of the Delimitation Commission. Now there can be a question here like with respect to independence of the Delimitation Commission. So it does get some secretariat assistance from the Election Commission, but Election Commission is also an independent body, so its independence will not get much affected. Let us now look into the duties of the commission. Duties obviously is very clear. There are 3 prime duties. 2 of them we know, that is the number of seats which are to be allocated to the state. Remember, number of seats are allocated on the basis of population. So roughly here you don't have to decide, because if you are considering the population, then this will automatically get changed according to the population figure. But this will be seen always that this adjustment has been done by the Delimitation Commission. It will be deemed as if this change has been done by the Delimitation Commission. So let us look into the duty. The first one, as we say, is the allocation of Lok Sabha and the Legislative Assembly seats to states, right? This will be deemed as readjustment. So here you do not have to do any work. Basically, it's just depending upon the population only you are adjusting it. But this will be seen as done by the Delimitation Commission. Second is, of course, the main process of delimitation is the readjusting the division, that is the constituencies within the states of both for the Legislative Assembly constituency as well as for the Lok Sabha. This is what we are calling as the actual delimitation of constituencies. And the third and important thing is that we know that there is a provision of reservation also in Lok Sabha as well as state legislative assemblies. So SCs and STs, they have been given reservation. Certain seats are going to be reserved for them. You will have to identify which seats will be reserved for them. Obviously, those constituency or seats will be reserved where there is a highest proportion of population of SCs and STs, right? This will also be seen state-wise. So this, which constituency or seats will be reserved constituencies or seats, this will also be decided by the Delimitation Commission. This is going to be their third duty. So determine seats reserved for SC and ST, and this, remember, is also on the basis of the 2001 census. Okay, which seats will be reserved will because you need to know the population, which constituency has a higher proportion of SC or ST. So that will also be on the basis of 2001 census. This is also provided in the constitution, and amendments have accordingly made in the constitution. Then one more thing is that while the delimitation of constituencies will happen, one thing has to be taken into consideration, and that is the assembly constituency should fall within the Lok Sabha constituencies, because assembly constituencies are there, like say 80 constituencies of Lok Sabha in UP, and then 400 odd constituencies are there for legislative assembly. So we should confirm the boundaries of the legislative assembly and the Lok Sabha constituency, so that suppose there is one particular constituency of Lok Sabha, so it may have, let's say, 4 or 5 legislative, there should not be overlap, like one legislative assembly constituency is falling in 2 Lok Sabha constituencies. So those kind of thing will make administration and the work of the entire election machinery and process very difficult. So all the assembly constituencies should fall fairly well within the boundary of the Lok Sabha constituency. This we have to consider, and this is mentioned in the law itself. Then let's see the factors which are taken into consideration for delimitation. Obviously population will be a factor, along with that geography will be a factor, and maybe the convenience of conducting elections, maybe of the people going to the booth, how easy it will be for people, how intelligible it will be for the people to participate in the process. Many such factors will be taken into consideration while you will delimit the constituencies. So the factors are, first and foremost, the geographical compactness, that has to be seen. You should not like have a very irregular kind of a constituency, like a star shaped constituency or anything. So the geographical compactness should be there. Physical features will also be seen, whether it's a hilly area, plateau area, marshy area. So those things will also be consideration, so that the movement of the people may not get affected. Existing administrative unit, we should try to conform it to the existing administrative units boundary, like for example district or block or tehsils. So as much of overlap as can happen with respect to, or their boundaries should conform to each other as much possible. But obviously the size will differ, no? The district size and the Lok Sabha constituency size will be different. District is going to be relatively on an average smaller in size in comparison to the Lok Sabha constituencies, right? So in that case, obviously it will not exactly overlap, but still some boundary should conform, right? So that administration becomes relatively easier. Then there should be facility of communication and public convenience, which should be intelligible for people also, and the way the amenities or other things are distributed already or existing, all those factors will be considered. And the assembly constituency should fall within the Lok Sabha constituency. This point I had already mentioned. So all these factors should be taken into consideration for the purpose of delimitation. Okay, next one is procedure and power. Here the process of how the delimitation is conducted is important, and in relation to that itself we will see some powers also and something separately as well. So let's see what are the procedure and power. First and foremost, the commission will determine its own procedure, right? So in the law itself it is written the commission, because the commissions are like independent bodies, so they are going to make their own rules, and through those rules itself they will be making their or coming up with their procedure. Okay, so it determines its own procedure. Then the civil court's power, these commissions will have the power of a civil court, as calling for the witnesses or taking evidences on affidavits, and all those powers which are there with the civil courts according to the Code of Civil Procedure 1908, that power will be there. They can ask any person to furnish any information. This power is also, because usually this power is anyhow there with the civil courts also. And then one more thing is that this is also related to their power, because the difference of opinion among the members, like 3 members are there and they have to take a decision. So the decision will be taken up by majority. So that means there may be a person who may be dissenting, he may be having a dissenting opinion also, or proposal as well. So we will see what happens to that. Now let's look at the process of the commission. So first of all, what the Delimitation Commission will do is that it is going to consider the population, it is going to consider all the factors of administrative convenience, public convenience, and all those which we mentioned, geography and rest of the things. It will take the help of the GIS and everything, and on that basis the commission itself will come up with a draft proposal from its own side. This draft proposal is going to be made public, and it is going to be circulated and widely discussed, and then the inputs will be taken up from the people. Remember that delimitation process, there may be political interferences also in the delimitation process, and a particular political party, any of the political party might just try to influence the process of delimitation so that the constituencies are delimited in a way where the political parties may be having some advantage when it is related to ease of winning the elections in those constituencies, right? Like for example, their particular vote banks in terms of any community, it gets separated in very few constituencies itself, right? Then they will be likely to win only fewer constituency. So this entire process, it can be politically interfered also. So that has to be, this is the reason why Delimitation Commission has to work with a lot of independence, and it has to be a scrutiny, or public scrutiny becomes a very important part of this procedure. So in the process of the commission, the public, it will first and foremost, the draft which has been prepared by the Delimitation Commission, it will be published, and in the publication, the proposal which is given, means its proposal as well as the dissenting proposal, as I told you. There may be a dissenting proposal also from one of the members. Both of them have to be published, right? If there is another opinion, that also needs to be published, and where it will get published as the first draft, it is going to be published in the Gazette of India and of the states. On the basis of this, you are basically considering the objections, right? You are inviting the inputs of the people, you are taking the feedback, in which the people may participate, the political parties and their representatives may also have to say something, the civil society may have to say something in this regard, maybe the lawyers have to make some representation. All the objections and suggestions, they are taken up, inputs, feedbacks are taken up, and then there will be public sittings, open public sittings, where the hearing will be made. These aspects are considered, and when everyone is heard and all the objections and suggestions, inputs, feedback taken, then the final draft will be prepared, right? That means readjustments in the draft will happen, and it will finalize its order, means its draft will be ready. This will come as an order. This order may be in the form of one or more order, maybe one for the Lok Sabha and rest of it for the state legislative assembly, or maybe for different state also it can come up with different orders. So it can come up with one order or it can come up with many orders. Overall, delimitation draft will be ready. Once it's ready, it gets finally again published in the Gazette of India and in the states. And one more interesting thing is that because the process is a very open and public process, public scrutiny is required. So what is important here is that it needs to be published. That means the commission itself will get it published, the final order, into vernacular newspapers so that people can easily understand, and it will be publicized on radio, television and all other possible media. So let us look into this. Accountability is another important issue over here in this process of delimitation, right? After all, it depends upon the conduct of free and fair elections, and for a democracy it is so important. The order which has been finalized thereafter, which has also been widely published now, this order will have the force of law now. As a law of the parliament has its effect, similarly the order of the Delimitation Commission will also have its effect. It cannot be questioned in any court, right? It cannot be questioned in any court. That means the order which is there, it cannot be questioned. The process of delimitation, whether the constitutional provisions were followed, whether the provisions of the laws were followed and all, those still can be challenged. But the order per se, it will not be challenged in the court. Second and third thing is that the order, the publication will also be placed in the Lok Sabha as well as it will be placed in the state legislative assembly. Remember, it is just played, it is laid before both these houses. There may be some observations, there may be some discussions, but I mean, it's not that it needs to be approved by these houses. It just needs to be laid before both the houses. Okay, now let's come to another issue of deferment of delimitation. Sometimes it may happen that a particular state, the process of delimitation cannot be conducted because maybe the environment in that state is not appropriate. Like maybe something like the situation of Manipur is there in any of the states, then it may be deferred. Like for example, when the 2001 census came and the 2002 delimitation was happening, that means the adjustment of constituency, then for some of the state it was deferred. For northeastern states it was deferred, for Jammu and Kashmir it was deferred. And how this deferred means the delimitation for the rest of the country will happen, but maybe for some areas it will be deferred. So how this deferment happens? For that also the provision is there in the Delimitation Act or the law itself. So deferment of delimitation, it happens on what grounds? First of all, if unity or integrity of India is threatened, something like an emergency kind of a situation, anywhere, any part, or if there is a threat to peace or public order. In these two bases, delimitation process may be deferred in a particular region or state. Then this will happen, deferment will happen by an order of the president, right? President by order will do this. This order of the president, it is also required to be laid in each house of the parliament. Remember, in each house of the parliament only, not in the state legislature, right? Only because it is a president's order, so it will be laid in each house, means it will be placed in the Lok Sabha as well as in the Rajya Sabha. Remember that the delimitation order, the final draft of the Delimitation Commission and those orders which it had passed, they will be placed in Lok Sabha and the State Legislative Assembly. But if a deferment of delimitation, the order is done by the President, it will be laid in both the houses of the Parliament, Lok Sabha as well as Rajya Sabha. Now one more interesting thing, as I was telling you that under Article 82, Parliament by law determines that which authority will conduct this readjustment or delimitation. Right, so it can give this power to another body apart from Delimitation Commission also, it is possible. So for that reason, what has been done, interestingly, you see we have a Representation of People's Act of 1950. In this Representation of People's Act, apart from this issue what I was mentioning, there are some other issues related to delimitation mentioned. Whatever orders the Delimitation Commission has come up with, whatever orders the Delimitation Commission, its final orders, the draft which had final one which it has prepared, which had publicized, those final orders will go to the Election Commission, because it is the Election Commission which has to bring about the changes in the boundaries, right? So implementation is to be done by the Election Commission. So Election Commission, what it does, according to the Representation of People's Act, Election Commission will consolidate these orders into one order, right? So whatever orders have been given by the Delimitation Commission, those orders, and it will implement those orders of the Delimitation Commission. So Election Commission will come up with its own consolidated one order by which all the changes will be brought into effect. Final orders by the, but see, the decision is only of the Delimitation Commission. What Election Commission is doing is that order of Delimitation Commission, it is just being implemented, and for implementation it is consolidating all these orders. Then the power of Election Commission to update orders at regular intervals, it can do some updates, maybe some information or some publication has to happen, something is missing, so those updates will happen by the, or whenever the census will happen or delimitation will happen, again it will have to update them. Now I was talking about that issue, right, that can any other body conduct the delimitation process? Now see, in the Representation of People's Act 1950 itself, an amendment has been made, and they have added this section 8A in the delimitation, in the Representation of People Act 1950, which says that, remember I told you that in 2002, when the delimitation was happening, it could not happen in some of the states, especially in the Northeast and J&K, though later on it happened afterwards. So here itself it is mentioned in 8A section 8A of the Representation of People Act 1950 that delimitation of parliamentary and assembly constituencies in the states of Arunachal Pradesh, Assam and Manipur or Nagaland, this is a provision. Let's see what is the provision with respect to these states. It says that if the president is satisfied that the situation and the conditions prevailing in the states of Arunachal Pradesh, Assam, Manipur and Nagaland, remember Arunachal Pradesh, Assam, Manipur or Nagaland are conducive, right? That means the order of deferment has already given, but later on president feels that now the condition has become conducive, right? So are conducive for the conduct of delimitation exercise, he may by order rescind the deferment order. That means the deferment order which he has given, he had made the order that here delimitation cannot happen. Now he can rescind that order. He can change that, and now he can say that now we can conduct the delimitation in these states, right? So deferment order issued under the provisions of section 10A of the Delimitation Act of 2002, क्योंकि 2002 के election 2002 के act में itself, they had mentioned that deferment can happen, right, by the order of the president. So that order is made under Delimitation Act of 2002. So in relation to that state, and provide for the conduct of delimitation exercise in the state by the Election Commission. So the power of conduct of delimitation has been given to the Election Commission over here. In these states, and this is the reason why in Assam, the delimitation exercise which was conducted, more than a year ago, it was done by the Election Commission. So I repeat this, what this section is saying. See, Article 82 makes it very clear that Parliament by law will determine that who will do the delimitation. So generally it happens by the Delimitation Commission. In the Delimitation Commission Act itself, it is given that President can defer delimitation. When President is deferring the delimitation, then in the Representation of People's Act of 1950, they have added that the President may have deferred it, but then the President later on by order may change, may say that now the environment is conducive and delimitation can happen. So he can cancel that deferment order and can conduct the delimitation in those states. But this here, which states are mentioned? Assam, Arunachal Pradesh, Manipur and Nagaland. And in these states, then the delimitation will be done not by the Delimitation Commission, because Delimitation Commission is already over. Now it will be done by the Election Commission. So this is what I wanted to discuss. And one more issue is there. Last one is, there is this term gerrymandering. This means that, as I was earlier mentioning, that this entire process can be politically influenced, right? Some political party might just try to gain some advantage through the process of delimitation. So when this political manipulation of the delimitation process happens to give advantage to certain political, denominations or parties, then that process will be called as, that political manipulation will be called as gerrymandering. Okay, so this is all as far as the issue is concerned. As I told you, the possibility which we'll have to see, the statement of the Home Minister has been given though, but it is not generating as much of confidence. We will have to wait and watch and see what happens after the census, and if required, maybe we will discuss it further. Thank you so much.